In the film adaptation of Mario Puzo's The Godfather, the story follows the Corleone family, Father Vito, son Michael, and their friends and relations who make up one of the five families, New York's most important mafia families. Toward the middle of the film, a mob war breaks out between the Corleone family and the Tattaglia family over the Corleones' reluctance to condone the narcotics business. At a peace meeting, one of the heads of the other five families, Don Barzini, brokers a peace between the Corleones and the Tattaglias, and an agreement that the Corleone family will grease the wheels with the police and the judges that they have been bribing all of these years, while the Tattaglias will pay a fee to the Corleones because, as Don Barzini says, after all, we are not communists. Whether in a crime cartel or the arguably more respected profession of the practice of law, money is a primary motivation for the things that most people do between 8 a.m. and 5 p.m. every day. Hello, I'm Roun McNeal, and this is the lecture series for Ethics in the Legal Environment. We're about halfway through this course, and in this unit, we'll be examining ethical issues related to lawyers' fees and client property. There's a joke I've heard about lawyers and fees. A man goes into a lawyer's office and demands to see the lawyer. He is escorted into the lawyer's office. The man needs legal help, but he knows how expensive lawyers can be, so he inquires, "Can you tell me how much you charge?" "Of course," the lawyer replies. "I charge $500 to answer 3 questions." "Well, don't you think that's an awful lot of money to answer 3 questions?" "Yes, it is," answers the lawyer. "So, what's your third question?" Being an attorney can be lucrative. There is no hard limit on what a lawyer can charge for her services except what the market will permit. Ethically, the profession requires that fees be reasonable. Of course, if a client agrees to your hourly rate, then the rate itself is presumptively reasonable. What may be unreasonable is the amount of time a lawyer charges and the total bill. One court put it this way: if attorneys' fees are not administered economically, efficiently, and expeditiously, they erode confidence in the justice system and erode the court's power to perform its functions. So the court and the profession do have an interest in making sure that attorneys charge reasonable fees, that otherwise the reputation of the profession suffers and the administration of justice suffers. The best way to be upfront, ethical, and honest in fee structuring is through a clear retainer agreement. Retainer agreements are the service contracts between attorneys and clients. You might also call these legal service agreements, client service agreements, or representation agreements. At the core of such an agreement, it establishes the work to be performed by the lawyer and the fees to be paid in compensation for that work. There's a great deal of diversity in the forms of provisions of retainer agreements. They might be in the form of contingency fee arrangements, which we discussed in the last unit, providing the lawyer a percentage of the recovery in a lawsuit. Many lawyers use hourly billing, where they can charge a certain amount per hour of work, one rate for themselves, one rate maybe for an associate attorney, and maybe another rate for a paralegal. Lawyers can also use flat rates for certain kinds of work. For example, when I was in private practice, I would charge a flat rate for an uncontested divorce and a flat rate for title searches. I might spend 2 hours on one client's title search. I might spend 4 hours on another's, but the rate charged would be the same. This is permissible as long as the client agrees. Whatever the fee type, the retainer agreement should clearly establish the scope and nature of the litigation. The agreement should name the parties and reference the specific litigation. For example, this retainer agreement is in reference to representation rising out of a car accident between client and an unknown driver on January 14, 2024, in which client sustained injuries and is seeking damages against the unknown driver, the manufacturer of her automobile, and other negligent parties, if any. Now note in that language the use of facts, dates, and causes of actions. Be as specific as possible. The agreement should also establish the working personnel. What office paralegals or associates can work on the matter? Can the firm hire third parties like investigators or accident reconstructionists? At what rate? Is there a ceiling on these kinds of expenses? The agreement should establish the fee type. As discussed a moment ago, this may be hourly, flat, or contingency. And there are special considerations sometimes in special cases, such as those where there is a possibility of awarding attorney's fees. The lawyer may want to make clear that if the court awards an amount of attorney's fees in excess of the attorney's fees actually billed, that the attorney is still entitled to the overage. The lawyer may want to make clear that expenses advanced by the lawyer, such as fees and travel for expert witnesses or costs of taking depositions, are reimbursed on top of the lawyer's fees and do not come out of her compensation. The lawyer may want to account at the beginning of the representation how much more she may be compensated if the case proceeds to an appeal. Clarity is the key, and clarity continues from the agreement stage to the billing stage. If the attorney is being compensated by the hour, he needs to keep regular and accurate timesheets. A timesheet is a detailed daily record of the time spent on each task performed by an attorney or paralegal for each client. In the legal industry, this kind of billing is referred to as the billable hour, or the time, totaling 1 hour, spent on a client's matter for which the client is responsible to pay, as the attorney's efforts relate to and benefit the client's matter. You can find an example of an attorney timesheet in a link to this video. Timesheets are the key piece of documentation in determining whether the fee charged is reasonable. Kept in real time, which means daily, they provide the proof of the work that the lawyer has done on that case. Associate attorneys who are supervised by a more senior attorney and other staff members usually will submit their timesheets to the supervising attorney for review before the client is billed. The supervising attorney may check for the specificity that is required in timesheets. Consider the facts of a fee dispute in Colorado Hospitality Services Incorporated versus Owners Insurance Company. Colorado Hospitality filed an insurance bad faith claim against Owners Insurance after a hailstorm damaged a hotel property. The insurance company offered $23,000, while Colorado Hospitality's independent adjuster valued the replacement cost at over $1 million. After a jury trial, the court awarded $42,000 in compensatory damages over the $23,000 that Owners Insurance had already paid, and ordered another $42,000 in punitive damages. But Colorado Hospitality filed a motion to force Owners Insurance to pay the attorney's fees for the trial in the amount of $333,000. Besides finding that the lawyers for Colorado Hospitality employed an excessive number of attorneys on the case, including 6 partner-level attorneys, which obviously inflated the bill, the court also found that the lawyers recorded time in, quote, large blocks of round numbers with vague descriptions of the work done. The lead counsel on the case recorded approximately 100 hours with the description of simply trial preparation. In some cases, 2 lawyers on the team working on the same project at the same time recorded inconsistent time entries. The court noted that the lawyer's practice was to make daily notes about work done and then summarize the notes weekly instead of contemporaneously recording the time, which can lead to inaccurate record keeping. Because of these errors, the court significantly reduced the number of hours billed and reduced the attorney's fees down to about $154,000. Beyond sloppy billing is intentionally inaccurate billing, which may be grounds for ethical complaints and discipline. Inaccurate billing is first a violation against the duty of honesty. In some cases, it may be outright theft. There are several ways that attorneys may engage in inaccurate billing. One is double billing. This is the practice of charging two or more clients for the same service and or the same time period. An example might be a paralegal who goes to the courthouse to file two motions in two separate cases. Let's say it takes the paralegal 30 minutes to walk to the courthouse, file the motions, and walk back. If he notes 30 minutes on timesheets for both clients, it's as if he worked an hour, which he didn't. He only worked 30 minutes. He is double billing. A related kind of inaccurate billing is padding. Let's say the same paralegal walks to the coffee shop on the way back from the courthouse and includes that time on the timesheet for the client. The paralegal has inflated the amount of time he actually worked for the client. Courts have characterized double billing and padding as not merely dishonest, but in actuality misappropriation or theft. In one Ohio case, Disciplinary Counsel versus Holland, the respondent, Holland, was a public sector lawyer who frequently represented juveniles in Stark County Juvenile Court by appointment of the court. Holland might represent multiple juveniles in a day, 2, 3, sometimes 8 in a single day. For each and every client, he would charge 3 hours, so that if he represented 8 clients on a day in juvenile court, he would bill for 24 hours, even though the court was only open for 7 hours each day from 8:30 a.m. to 12 and then again from 1 to 4:30. The court found that Holland violated his duty of honesty, which in the ABA model rules is present in Rule 8.4. The court also found that padding client bills with hours not worked is tantamount to misappropriation. And when professional conduct involves misappropriation, disbarment is the presumptive sanction. The court in this case chose not to disbar Holland, but rather merely to suspend him for the practice of law for a year in order to him to repay all fees charged, which is still a pretty significant sanction. Let's shift gears and return to the concept I mentioned at the beginning of the lecture: reasonable fees. Besides an ethical duty to charge reasonable fees, there is also the practical implication that in some cases, one side in a lawsuit might be awarded attorney's fees by the court. So, in addition to the normal compensatory damages, a party may be awarded an additional amount of money to cover their attorney's fees. In such cases, the court will request that the lawyer to submit evidence of their attorney's fees, mostly timesheets, and the court will review that evidence to make sure that it is reasonable. This is exactly the kind of process that happened in Colorado Hospitality Services versus Owners Insurance Company. A reasonable fee is a charge for legal services that accurately reflects the time, effort, and expertise spent on a client matter. Whether fees are reasonable is evaluated on a case-by-case basis with a fact-specific inquiry, and there are several factors to consider. First and most straightforward is the amount of time and labor required to perform the task. Second, the skill and experience of the legal professional must be considered. A senior partner with 30 years' experience can reasonably bill more per hour than a junior associate fresh out of law school. Rush orders and impending deadlines might call for a premium on hourly billing, as might a particularly high demand client who needs access all the time and at odd hours. The local market is an additional factor in considering reasonableness. The going rate in Houston, Texas is probably a little higher than the going rate in Houston, Mississippi. The complexity of the work can also influence rates. A multi-million-dollar commercial real estate transaction may merit a higher fee than traditional residential home loan closings. And finally, it is generally accepted that risk of collecting the fee can influence reasonableness, meaning contingency fee cases, where the lawyer is taking on all the financial risk, merit a reward of higher fees than an hourly billing case where the lawyer is reasonably confident that he will be compensated. These factors are not hard and fast, and different jurisdictions may have slightly different factors for determining whether fees are reasonable. In determining whether a lawyer's fees are reasonable, the lawyer may put on evidence of the customary fee of the locality. Testimony from another lawyer who has handled similar matters can establish that the fees are customary. Two more factors can influence the reasonableness of fees: the experience and reputation of legal specialists, and the length and history of the legal relationship. Some attorneys develop special expertise in legal areas. Their reputation as a specialist, with a quote unquote boutique law firm handling very specific clientele, may allow them to charge a premium on fees. Sometimes this reputation is burnished by achieving a certified specialist status. A certified specialist is a lawyer who's been acknowledged to have specialized and demonstrated knowledge in a particular area of law by a bar recognized legal association. Finally, the length and nature of the relationship between the lawyer and client may influence whether fees are reasonable. A decades old case from Mobile County, Alabama, deals with a number of legal fee issues, including the nature and length of the professional relationship. In Peebles versus Miley, the Alabama Supreme Court recognized that an attorney who is the attorney for a client who has frequent and continuing legal problems may make appropriate adjustment of the amount of the fees charged. What would be a reasonable fee to such a client may not be the same as for a client who sees the lawyer for the first time. For instance, a suit against a police officer may effectively preclude employment by suing the lawyer of any business from police officers. Because of this potential loss, a lawyer, in setting reasonable attorney's fees, may take this into consideration. Now, in the second lecture in this unit, we will discuss paralegal fees, fee splitting, and issues surrounding the safekeeping of client property, particularly retainer fees that remain the client's property until the lawyer properly bills the client. So, until next time.